First, let me say it is an absolute pleasure to be here, and I am so impressed by the turnout. And I want to thank Ibrak for inviting me to participate. This is, I've been in this position for about 1 year, and this is one of the highlights of my job so far is to be able to be here today. So thank you very much. I want to talk about leniency, confidentiality, and the importance of balancing confidentiality concerns with the rights of civil litigants in the United States. So I will be talking from the perspective of the government, and then Ed Schwartz, I think, will be adding the perspective of the private defense bar. First, let me say that the Department of Justice's corporate leniency program is one of the most important tools that we have in fighting international cartels. It has been in place since 1993 and has really revolutionized the way that we detect and prosecute international cartel conduct. And one of the key components to our leniency program is confidentiality. When leniency applicants come in and request leniency from the Department of Justice, they know that we will work very, very hard to protect the confidentiality, both of their identity as a leniency applicant and also of the information that they provide us. And that is very important because if companies believe that we will take their information and share it with civil litigants or even share it with other competition authorities, they may be less likely to come in and seek leniency for us. It may chill them and chill their willingness to come in and self-report. So we take confidentiality very, very seriously, and as I will describe in a few minutes, we will litigate if necessary. We will intervene in civil litigation to try to protect the identity of our leniency applicants and the confidentiality of the information that they provide us. But more significantly, I think what makes the U.S. system maybe a little bit different than some other systems is that we are pursuing cartel conduct criminally in the United States. So these are criminal investigations, and there are confidentiality requirements that extend to our criminal investigations as a whole, whether they are the result of a leniency applicant or not. So I want to take just a few minutes to talk about the confidentiality obligations that exist in U.S. criminal investigations. When we open a cartel investigation in the United States, and we will open it as a criminal investigation if it involves price fixing, bid rigging, or some type of allocation agreement, a customer allocation or a geographic allocation, for instance. Confidentiality extends to that entire investigation. And confidentiality is important for two main reasons. First, confidentiality is important because our investigation must be able to proceed without interference. So as we will get to in a few minutes, there is always a tension between our investigations and civil litigation, and we very often will try to prevent discovery and proceedings in the civil cases that could interfere with our investigation. Secondly, confidentiality is important because we always end up investigating individuals and sometimes companies that ultimately are not charged criminally, and they have rights not to be identified publicly as the subjects of our investigation. In the United States, they actually have a due process right or a due process protection against being publicly identified as the subject of a criminal investigation, because that can do harm to their reputation, and if they are never charged, they never have their day in court to clear their name. So confidentiality is important to protect the identities of individuals who may never be charged. Once the initial, what we call a preliminary investigation stage of a criminal investigation is passed, all criminal antitrust investigations, whether leniency or non-leniency, in the United States are conducted using a criminal grand jury. And under our federal rules of criminal procedure, the government is not allowed to disclose any matters that are occurring before the grand jury for the reasons that I've just discussed, both to protect the integrity of the investigation and also to protect the rights of people that may be under investigation and never charged. So this obligation of grand jury secrecy extends both to leniency and non-leniency information that is provided to the grand jury. And that secrecy right remains in place until a case is actually charged. After indictment, information, including leniency information, must be shared with the criminal defendant who is preparing for trial. They are entitled to have all of the information available to the government so that they can know the government's case and also so that they can prepare a defense. However, typically in our cases, we will enter into a protective order. So we will provide information to the criminal defendant, including leniency information, the identity of the leniency applicant and any information they've provided us, but that is maintained as confidential within the case. So the defendant is not able to turn around and provide that information to anyone outside of the case. With court permission, information that is provided to the grand jury can, on occasion, be shared with other U.S. law enforcement officials, both federal and state, if it relates to criminal investigations that they are conducting. Again, though, when it's being provided within the U.S. law enforcement community, the grand jury secrecy rules continue to apply to that information, and those law enforcement officials can't publicly disclose the information. Finally, there are treaties that exist between the United States and other countries, mutual legal assistance treaties, that provide for exchanges of information and documents between countries in order to conduct criminal investigations. So there are occasions when we will receive an MLAT request from foreign jurisdictions requesting information provided to us by a leniency applicant or leniency documents. And if the MLAT is complied with and there are the types of restrictions that both countries would want to have in place respecting the confidentiality of those records, then it can be exchanged between countries. Private parties have very limited access to grand jury materials, however. Private parties aren't, the grand jury secrecy rules apply and really guard information given to the grand jury from being provided to private litigants, except where there are special circumstances and a court orders it. That doesn't mean that civil litigants can't get documents that have been produced to the grand jury, for instance, by the leniency applicant. It just means they can't get them from the United States. They would have to go in civil litigation and get those documents directly from the party. The Antitrust Division treats leniency applicants with similar confidentiality. So they're treated like confidential informants. We don't disclose their identity or their information unless either ordered by the court or unless the leniency applicant consents. We won't disclose the information to enforcers from other countries unless the leniency applicant first agrees to the disclosures, again, because we don't want to undermine the incentive to self-report. And although we're obligated to provide victims of crimes, including antitrust crimes, with certain types of notifications and consultations, the division has no obligation to provide discovery or information in civil litigation. We don't and we can't use evidence developed in a criminal investigation to advance any civil litigation. Nor do civil litigants really need our help, and you're going to hear more about this from Ed in a few minutes. Civil litigants in the United States have very, very broad civil discovery available to them when they litigate in U.S. courts. So essentially, private litigants have the ability to subpoena virtually anything that the government can ask for, and sometimes even more. And civil discovery is extraterritorial. So if you are a foreign company involved in litigation in the United States, you may very well have to produce your foreign located documents through civil discovery in the United States. The Antitrust Division, on the other hand, typically does not compel extraterritorial evidence in criminal investigations. So when we serve a subpoena, it's limited to documents located in the United States. When we execute search warrants, we are taking information located in the United States. We are not generally requiring or compelling production of overseas materials. So civil litigants oftentimes will have access to things that we don't get access to unless a subject company voluntarily gives us their overseas documents. Nonetheless, civil litigants very often try to subpoena material from us either to get it more quickly or really to obtain summaries of our interviews and testimony of witnesses that either they have not yet been able to interview or they may not be able to interview for some reason. Or occasionally we have covert recordings, either audio recordings or videotapes of price-fixing meetings and price-fixing telephone calls that are available to us and not to civil litigants. And so we often will receive subpoenas for those types of materials, which when that happens, the Department of Justice will seek to protect information and guard it against disclosure and civil discovery when parties in those civil suits ask us to. So private litigants usually have broad powers to issue subpoenas or document or other discovery requests for information that is helpful to their cases. Sometimes they will serve a subpoena on the government. The Department of Justice has to comply with special regulations that require us to object when responding to a subpoena. If the subpoena would require us to reveal grand jury information, if it would reveal a confidential source or informant, such as a leniency applicant, if it would interfere with an ongoing investigation, if it would violate other privileges, such as a law enforcement privilege. The bottom line is that private parties in civil lawsuits can't use us as a shortcut to discovery that they can obtain amongst themselves. Parties sometimes file requests under the Freedom of Information Act, which is a U.S. statute that requires the U.S. to be as transparent as possible, and it's designed to ensure good government. But it's not supposed to serve as a tool for discovery in civil litigation. So there are exemptions to FOIA requests that keep information confidential that are similar to the other protections for confidential information, such as FOIA doesn't require us to disclose matters occurring before the grand jury. It doesn't require us to disclose records that would interfere with an ongoing enforcement proceeding or would reveal our law enforcement techniques. It doesn't require us to disclose confidential informants or the information they provide us, or to provide our attorney work product, or documents that reveal our deliberative process, or to allow us to produce information that would constitute an unwarranted invasion of someone's privacy. So we will receive the subpoenas, and when we receive them, we will normally object to the requests if we have a basis for doing so. Sometimes it's then necessary for us to actually intervene in the civil lawsuits in order to try to stay discovery when parties seek either information about our investigation from the United States or they seek it from each other. So in the United States, civil litigants, as I mentioned, have the ability to issue broad discovery requests, especially to defendants. And defendants often include leniency applicants and other companies that are cooperating with our investigation. Those defendants oftentimes have incentives to cooperate with the civil plaintiffs. Leniency applicants, for instance, can cooperate and receive reduced civil liability under federal statute. Other defendants may also choose to cooperate in exchange for negotiating discounted settlements. The Antitrust Division generally tries to stay out of civil discovery issues, but we will sometimes intervene in private civil suits if discovery in the private case creates a risk of interference with the grand jury investigation or any resulting criminal cases. And decisions about whether to intervene in a case are made on a case-by-case basis. It just depends on the status of their case, the status of our investigation, what the civil plaintiffs are seeking or any of the defendants are seeking in the way of discovery. And we will make a decision and intervene where it's necessary. And in fact, just yesterday, we intervened and were able to get an order to stay discovery in an investigation of the capacitors industry that the Antitrust Division is involved in right now. So the factors that we consider in whether we consider in deciding whether to intervene and seek a stay include whether the civil discovery will lead to disclosure of grand jury information or covert aspects of the investigation or even spin-off investigations, whether it's going to disclose the identity of our cooperators and lead to witness intimidation, whether it's going to give non-cooperating defendants a roadmap to our investigation or our case theories. So sometimes we don't mind if the civil plaintiffs have an understanding of our cases, but whatever information the civil plaintiffs get, the defendants are also going to get. And these could be defendants that are still under investigation, and they don't have a right to discovery in a criminal case unless they're charged. And so sometimes defendants view civil discovery as a vehicle for trying to figure out what our criminal investigation looks like, and we will intervene and seek a stay in order to prevent that. It also allows, where we have grand jury subjects and defendants that are using civil discovery to circumvent our federal rules of criminal procedure and get premature discovery, again, is a reason that we would intervene. And finally, and this oftentimes is the most important factor, if key witnesses in the criminal investigation are going to be deposed in civil litigation, we will often intervene and seek a stay because we don't want to have the civil litigants questioning witnesses and creating transcripts of witness testimony before either the grand jury or a criminal trial jury has had the opportunity to hear from those witnesses. So the division, when it intervenes in a case, it can ask for a complete stay of discovery or a partial stay. Typically, we won't ask for a stay that is longer than a year without reapplying to the court. Generally, courts that have civil cases want their cases to move along, and if we just come in and ask for an open-ended stay, they're not going to like that too much. So we typically will come in and ask for either a 6-month or a 1-year stay with the opportunity to revisit it if we think our investigation requires it. And we can often reach agreement with the civil parties about a stay and about how they might stage their discovery in ways that protects the integrity of our investigation while still allowing some discovery to take place. So we might say we're fine with document discovery going forward, but we don't want depositions to take place. Or we might say that they can take certain types of discovery related to class certification, but not to the merits. So we often will try to negotiate these things with the civil plaintiffs and with the defendants and enter into a stipulated stay that everybody can agree to. And examples of recent investigations where the court has granted either complete or partial stays includes our auto parts investigation, our investigation of liquid crystal displays or LCDs, air cargo, municipal bonds, and as I mentioned just yesterday, capacitors. The process doesn't seem to interfere with the ability of civil litigants to win substantial awards, including in many of the investigations that I just mentioned where we issued a stay. It just slows it down a little bit. But our ability to protect the confidentiality of law enforcement materials generally is always going to take precedence over civil litigation, at least while we have an open law enforcement investigation. Once the investigation closes, sometimes our ability and really our need to protect some of those materials does diminish over time.
Thank you.
Thank you.